Hello and welcome to this video companion for PA 261, Bankruptcy and Debtor Creditor Law. Today we are going to examine Chapter 7, Bankruptcy Proceedings. So let's begin with a foundational concept behind Chapter 7. So Chapter 7 is built around what courts often call the fresh start principle. And the basic trade-off is this. Non-exempt assets may be liquidated in exchange for the debtor receiving a financial reset. And there are three core pillars here. The first is the automatic stay. The moment a bankruptcy petition is filed, most collection activities must stop immediately. This includes like lawsuits and garnishment of wages and foreclosures and repossessions, etc. The stay operates automatically. There's no hearing that is required for this. However, secured creditors can ask the court for permission to proceed if they meet certain standards. Second is exemptions. Exemptions are determined by what property the debtor is allowed to keep. And finally, discharge. The discharge eliminates personal liability on qualifying debts. It doesn't eliminate liens. That distinction is critical because we'll need to look at that later. Before we go further, we need to understand how equity works because it's a critical concept. As you can see from this slide, this illustrates one of the most important calculations in Chapter 7, which is equity. When we talk about equity, we are talking about market value minus the secured debt. So exemptions protect the equity portion, not the full value of the property. So here, let's just use a simple example. If a home is worth $300,000 and the mortgage balance is $290,000, the debtor has $10,000 in equity. That $10,000 is what we compare to the homestead exemption. If the exemption exceeds $10,000, the trustee cannot administer the property. But if the equity exceeds the exemption amount, the trustee can sell the property, pay off the mortgage, return the exempt amount to the debtor, and distribute the remainder to the unsecured creditors. This is why accurate valuations in Chapter 7 proceedings are essential. So now let's go to inflated adjustments. So federal bankruptcy exemptions adjust periodically to account for inflation. And the most recent update came effective on April 1st, 2025. And these updated figures apply to cases filed on or after that date. So the purpose of these adjustments is to preserve the real economic value of exemptions in an inflationary environment. So let's go ahead and examine what those amounts are. So here are the core exemption amounts under the current federal system. You have the homestead exemption, which is $31,575 per debtor. And this protects equity in a primary resident. If married debtors file jointly and both own the property, they can typically double that amount. Now, the motor vehicle exemption is $5,025 in equity in one vehicle. The household goods exemption is $16,850 aggregate limit with an $800 per item cap. Now, the per item cap prevents someone from shielding a single high value luxury item by labeling it as a household good. Now, these exemptions focus on preserving the essentials of a debtor's daily living. So next, let's look at the flexibility tools within the exemption system. Here you can see two particularly powerful protections. The first is the wild card exemption, and it includes a base amount of $1,675, as well as up to $15,800 of unused homestead. So that means a debtor who does not use the homestead exemption, like a renter, may protect up to $17,475 in any property. And this exemption is strategically significant in consumer cases. Second, let's look at tools of trade. Debtors may protect up to $3,175 in tools necessary for earning income. And finally, is the retirement accounts. Most tax qualified retirement accounts are strongly protected up to $1.7 million. In many cases, the retirement assets are effectively beyond that reach of the trustee for creditors in bankruptcy protection. Now let's discuss geography, because exemption strategy depends heavily on where the creditor actually lives. So not all debtors may use the federal exemption system. Many states, as you can see here, have opted out, meaning that residents must use state-specific exemptions. And in these cases, debtors generally cannot mix federal and state systems. They need to use one complete system. Additionally, there's also what is known as a domicile requirement. A debtor must use the exemption of that state where they live for the prior 2 years to the filing. And if they moved recently, they can employ what are known as look-back rules. So this prevents individuals from relocating simply to take advantage of a more generous exemptions offered by a different state. Let's talk about the timeline for a Chapter 7 proceeding. And there are four major phases. The first phase is filing, and this is where the petition is filed and the automatic stay begins immediately. Second is the administration. A trustee is appointed, creditors receive notice so that the administration of that proceeding can begin. Third is known as the meeting of the creditors, and this is typically 21 to 40 days after that initial filing. This meeting is conducted by the trustee, not a judge. The debtor testifies under oath, answers standardized questions about assets, income, and any prior transfers. Creditors may attend, but rarely do they in routine consumer cases. And fourth, you have the discharge. If there are no objections that are filed, the discharge is typically entered 60 to 90 days after the meeting of the creditors. So let's talk about the critical distinction between discharge and reaffirmation. The discharge eliminates those personal liabilities for qualified debts. So it voids judgments and permanently prohibits collection of efforts. However, it does not automatically remove liens. That means secured creditors may still enforce their rights against collateral. Reaffirmation is different. A reaffirmation is an agreement that is voluntary. It allows a debtor to remain personally liable for specific debts, like to keep a vehicle. The reaffirmation agreement must be properly filed and included detailed disclosures to protect the debtor. In some jurisdictions, court approval may be required for that. And it's important to understand the reaffirmation is a choice, is not a requirement. So please don't forget, with Chapter 7, it's a structured trade-off. Non-exempt assets may be liquidated. In exchange, the debtor receives a discharge and a financial reset. Exemptions are determined by what property is protected. The automatic stay provides immediate protection, and the trustee administers the estate. And the discharge delivers a fresh start to the debtor. I hope you found this video helpful and insightful to sort of remove some of the mystique or mysticism surrounding Chapter 7 bankruptcy proceedings. Thank you and have a wonderful day.